Morning. The Subcommittee on Elections of the Committee on House Administration will now come to order. Let me say good morning to each and every one of you. Thank you so very much for joining us today. As we begin this hearing, I want to just make a few notes. First, let me note that we are holding this hearing both as an in-person hearing and we are doing it remotely. We are doing it in compliance with the regulations for remote committee proceedings pursuant to House Resolution 8. Generally, members, please remember to keep your microphones muted when not speaking. This will limit background noise, and you should unmute when you are recognized. If you are joining us virtually, please also keep your camera on at all times. For those joining us in the hearing room, we are holding this hearing in compliance with the guidance issued by the Office of the Attending Physician, and everyone should continue to please wear their mask except when speaking. At this time, I ask unanimous consent that the Chair be authorized to declare recess of the subcommittee at any point, and that all members have 5 legislative days in which to revise and extend their remarks and have any written statements be made part of the record. I hear no objection. It is therefore ordered. House Resolution 8, the House Rules Package, requires members and requires committees or their subcommittees to hold a hearing during the first session of the 117th Congress in which they receive testimony from members and from delegates and the resident commissioner on proposed legislation within their jurisdiction. In accordance with these rules, the Subcommittee on Elections is holding today's Member Day hearing. The Subcommittee on Elections jurisdiction encompasses a wide array of matters relating to election administration, voting, and federal elections generally. As a committee, we take this charge very seriously. In the last year, the subcommittee held 5 hearings focusing on voting in America and ensuring every American has free and fair access to the ballot box. The subcommittee heard testimony from more than 35 witnesses. We examined a range of topics such as voter list purges, voter identification and proof of citizenship laws, the lack of multilingual support for voters, and the quality of polling places and restrictions on opportunities to vote. We talked about methods of election and that all-important subject of redistricting, all of which, when wielded with discriminatory or suppressive intent, can hinder a voter's access to the ballot box. The committee held 3 hearings on election matters, focusing on strengthening our democracy, the Elections Clause, and the growing threat of election subversion. And so we are pleased to hear this morning from colleagues who are not on this committee, but who wish to share their legislative ideas and proposals with us. I now want to recognize my dear friend from the state of Wisconsin, and I wish you and your family, sir, a very Merry Christmas and Happy New Year. It's been a pleasure to work with you this year. Even though we sit on opposite sides of the aisle, I think you and I have developed a very respectful and reciprocal relationship. So thank you so very much. I yield to you at this time.
Thank you, Mr. Chairman. I wish you and your family a Merry Christmas and a Happy New Year as well. You'll be sorely missed next Congress. Although we sit across the aisle from each other, I have enjoyed working with you.
Thank you.
House rules state that during the first session of the 117th Congress, each standing committee or each subcommittee thereof shall hold a hearing in which it receives testimony from members, delegates, and resident commissioners on proposed legislation within its jurisdiction. Today, 348 days into the session, Chair Lofgren is just now fulfilling this requirement, but chose to do so without the full committee. This requirement is being fulfilled by our subcommittee on elections. Oversight of federal election is important and a key piece of this committee's jurisdiction. But elections are only a fraction of what members should be able to speak to during a true member hearing day. We should be able to speak that the Capitol, the People's House, is not open for tours. It is not open to the people. We should be able to talk about mask requirements on the House floor. We should be able to talk about metal detectors for members of Congress. But today we're having a hearing on the Friday before Christmas. It's almost like you'd think the Democrats are trying to hide something from their public about the bad policies of their legislation. Kind of like they did in rushing through H.R. 1, the federal government takeover of elections, over 800 pages of a one-size-fits-all mandate to states and localities on every minute detail of how elections should be operated. H.R. 1, as we know, would have gutted voter ID laws. H.R. 1 would have nationalized elections, would have restricted states' abilities to maintain accurate voter rolls, and would have provided a handout to politicians with a 6-to-1 match of small donations funded with taxpayer money. This process is now repeating itself in the Senate, where they're trying to pass a, quote, compromise voting bill right now, just before the end of the year, just before Christmas, when nobody's watching. But really, the bill in debate in the Senate is just a shorter version of H.R. 1 and would mandate that mail-in ballots be accepted if they're received 7 days after the election. It would weaken states' voter ID requirements. It would mandate automatic voter registration. And it would nationalize our election system and centralize the administration in Washington, D.C. Let's just take a couple seconds to reflect on what this Democratic majority has done when it comes to our role overseeing federal elections. Every day, we hear from the other side about how our democracy is under threat. We hear about how critical it is that we pass partisan elections agendas to save our democracy. The reality is, what they have done and continue to do through their rhetoric, their actions, their policies, is a threat to our democracy. Let us not forget that it was the Democrats on this committee that attempted to steal an election in Iowa's 2nd Congressional District, despite the race being certified, and contemplated trying to steal a seat in New York's 22nd Congressional District. The Democratic majority only backed down after facing a backlash from the public once they realized they didn't have the votes to get it done. You want to know how to protect democracy? You can start by not nationalizing elections in order to rig the outcomes in your favor. You can start by not using sensational language that undermines people's faith in elections. And you can start by not trying to steal elections for congressional seats that were duly certified according to the law. I will continue to fight to make it easy to vote and hard to cheat. I appreciate our colleagues who've worked around the outgoing majority's attempt to do anything and everything to make today's hearing as inconvenient as possible in an attempt to stymie members' voices. I remind you, it's about 5 a.m. in Alaska right now, and they want to be held not accountable for the way the House is being run. I do, though, look forward to today's discussion, Mr. Chairman. I think it'll be lively and appreciate you holding today's hearing. I yield back.
Joined by several members. The first member that I will recognize is Congressman Peter Meyer. Peter represents Michigan's 3rd Congressional District. Peter serves on the Committee on Homeland Security, the Committee on Foreign Affairs, and the Science, Space, and Technology Committee. Congressman Meyer, we welcome you today. You're recognized, sir, for approximately 5 minutes.
Thank you, Mr. Chairman and Ranking Member, for holding today's Member Day hearing. Ensuring integrity within our electoral process remains a critical concern of mine and of my Republican colleagues who are testifying here today. The legitimacy of our democratic order rests on public confidence in the integrity of our elections. However, in recent years, politicians on both sides of the aisle have sought to undermine that confidence and advance their personal or partisan aims. This erosion, combined with the difficulties of administering the 2020 election amidst a pandemic, led to an acute crisis of confidence where baseless claims of voter fraud and voter suppression echo one another and produce the same disillusioning results. At this perilous moment in American democracy, the people in this chamber should seek to restore faith of the voting public in the integrity of our elections. And instead, we have H.R. 1. Now, this bill does two things at the top. First, it strips states and local governments of their ability to determine how best to administer their elections, choosing instead to make the federal government, the part of our federal system at greatest remove from the voters, the primary rulemaking body. Then it goes on to make the federal agencies responsible for administering those rules explicitly partisan by changing the structure of the FEC from 6 to 5 members. It goes even further by removing the requirements for bipartisan agreement before the FEC initiates action, an important check against those partisan impulses. And it also enables the IRS to discriminate in its issuance of fundraising permits on the basis of partisanship and issue focus, politicizing the tax authorities in addition. I cannot think of a system better designed to undermine public confidence than that proposed through H.R. 1. First, you remove the rulemaking authority as far as you can from the public, as far as you can from accountability, and then you make those enforcement mechanisms explicitly partisan. Even in the event that a partisan majority acted completely above board in pursuing an offense, it would be impossible for the FEC to defend itself against charges of partisanship because it would be partisan by definition, given its slanted structure. The conspiracy theories here write themselves, and yet under our structure, proposed by H.R. 1, the conspiracy theories will be the least of our worries. As the drafting of H.R. 1 itself has shown, the temptations to abuse a partisan structure for partisan ends are more than most legislators can resist. The overall structure of this bill is fatally flawed, but even in detail, it is still yet a fiasco. Now, I've limited time here, so I'm unable to address the many, many deeply flawed provisions in this bill, but is it even necessary to discuss the obvious consequences of replacing voter ID with signed affidavits? Or the folly of dignifying the concept of fake 10-to-1 donor match by midnight email scams with a 6-to-1 match from the very real American taxpayer? Worst of all, I don't have time to delve into the incredible burden that these mandates would impose on state and local election administrators, or the wave of frivolous lawsuits and election challenges that those burdensome mandates would produce, achieving, once again, the polar opposite of the stated aim of H.R. 1. That is the real tragedy. The COVID-19 pandemic created an organic nationwide experiment in election administration procedures, and America's election administrators performed heroic work under trying circumstances. In some cases, these changes created unintended consequences that undermined voter confidence. In others, they enhanced voter confidence through innovative solutions that improved access and turnout. Our Congress, the 117th, had a unique opportunity and an imperative to work together to sort through these changes and secure the trust of the electorate. Now, that work may yet be done, but it will not be accomplished through the partisan bills we have before us. And with that, I thank Mr. Chairman for the time, and I yield back.
Thank you, Congressman Meyer. The gentleman yields back. I'm informed that the ranking member of our full committee has joined us today. I'm very delighted to recognize him at this time, Congressman Rodney Davis from the great state of Illinois. Rodney is also my neighbor in the Rayburn building. We see each other quite frequently, and I appreciate your friendship, Rodney, and I'm going to yield to you such time as you may consume.
Well, Mr. Chair, it's been great working with you. I've enjoyed our time together on the committee and our time together as neighbors in the Rayburn office building. Ranking Member Stiles, thank you for being here today and your hard work on this subcommittee. And thanks for welcoming me to share a few remarks. The People's House is beyond mismanaged. It is broken. Over the course of these past 3 years, Speaker Pelosi and the House Administration Committee Democrats have manipulated the rules at every turn. They've weaponized the institution and its support entities to consolidate power and politicized the day-to-day operations of the House. Member Day hearings were created in House rules by the Democratic majority, and now they are the ones attempting to avoid them. Opening our committee to fellow members from all regions, seniorities, delegations, and parties is a sign of respect. In typical fashion, the Democrat majority has pulled out all the stops to suppress members' opportunities to have an audience with the committee that is responsible for executing the Speaker's weaponization of the institution by doing this hearing right before Christmas and housing it with our good chairman, Mr. Butterfield, who I have the utmost respect for. And I know this wasn't his decision, but housing it with the committee's subcommittee on elections. As a recap, here are just a few of the things that have happened this year under the Democratic majority. They failed to properly oversee the security of the Capitol complex on January 6th, leaving members and staff completely exposed, took no responsibility for it, and have made no meaningful changes since to ensure it doesn't happen again. They allowed a Democrat member to be on the House floor so they could vote in the Speaker election days after testing positive for COVID, risking the health of every member while not affording the same opportunity to Republican members. They have politicized guidance coming from the Office of Attending Physician related to COVID-19 to justify mask mandates and to keep the People's House closed to the American people, while on the other side of the same building, tours have resumed and no mandates exist. They manufactured a false narrative about Republican members being a threat to Democrat members and passed a rule requiring members to go through magnetometers or face fines. In practice, only Republican members have been fined despite video evidence of the speaker and other Democrats failing to follow the same requirement. At the same time, this committee has failed to execute even its most basic administrative functions. Here are just a few examples. A Republican member submitted to the committee on August 18th a standard request to allow the MRA to cover damages to a rental car that occurred in the course of official duties. It took the majority of this committee 10 weeks to approve the request. The Committee on Ethics and minority staff of this committee produced draft joint guidance for members and staff on multiple different issues in August of 2020. Majority staff of this committee did not even respond until September of 2021, over a year later. A Republican staffer of this committee was out over $500 of their own money for over 14 weeks, while the majority staff of this committee failed to process his reimbursement request. These are horrible precedents to set. As we on the committee are aware, House Administration is a unique committee because so much of what we do is inward facing to our institution. We are a member service committee. The mission I've set for my team is to make the House work, because a stronger, healthier, and more efficient institution can serve all Americans better. It's well past time for accountability and for the majority members of this committee to understand the frustration and negative impact their decisions and actions have had on members' ability to do their jobs and represent our constituents and the American people. I'm grateful for the members who have put forth the time and effort to be with us today to share their experiences and their feedback. And with that, Mr. Chair, I yield back.
I thank the ranking member. The gentleman yields back. At this time, the chair recognizes Congressman Mike Johnson. Congressman Johnson represents Louisiana's 4th Congressional District. He serves on the House Armed Services Committee and the Committee on the Judiciary. Congressman Johnson, you're recognized, sir, for 5 minutes.
Thank you, Mr. Chairman, and Ranking Member Stile, Ranking Member Davis of the full committee, all my distinguished colleagues who serve on this subcommittee. This is an important one. We're really grateful. Wish you all a Merry Christmas. Thank you for having this hearing. Look, I think every member of Congress would agree that the processes put in place for the 2020 election ultimately sowed a lot of doubt into the minds of millions of Americans about the integrity of the vote in this country. Under the pretext of responding to the COVID-19 pandemic, and in many cases at the last possible moment, many governors, secretaries of state, state political parties, judges, other actors went around the constitutional authority of state legislatures to set new parameters for how the election would be administered within their states. The glaring problem with all of that is that it was contrary to the express language of the Constitution itself. For example, in Article 2, Section 1, Clause 2, it is the state legislatures only that are entrusted with the integrity of our unique election system, and they're given the exclusive authority of directing the manner of appointing presidential electors for the Electoral College. As the Supreme Court itself affirmed almost 130 years ago in McPherson v. Blacker, that power is, quote, placed absolutely and wholly with the legislatures, and it can never be taken away nor abdicated, unquote. All of those unprecedented and unconstitutional changes in 2020 led to widespread irregularities that undermined Americans' faith in our institutions. And that's the real threat here. So how did congressional Democrats respond? Well, they doubled down on that usurpation of state power by reintroducing H.R. 1 and H.R. 4 from the last Congress. As we know, H.R. 1 would nationalize elections, centralize election administration in Washington, D.C., which again is a direct violation of the plain language of the Constitution. Remember that Article 1, Section 4 gives the states their primary role in determining their registration and voting practices. H.R. 1 would provide no excuse absentee voting with virtually no verification of the voter's identity. It would automatically give felons the right to vote. It would require increased disclosure requirements for only certain political donors, which likely violates the First Amendment and would chill free speech of countless Americans. It would empower the IRS to launch politically motivated investigations against conservative groups, and among many other things, would make pandemic-specific election reforms, all the chaos that was created last year, it would make that permanent. All these policies are terribly misguided, but perhaps the most egregious provision in H.R. 1, the one that will really alarm the American people when they figure this out, are those that would provide taxpayer funding for political campaigns. I mean, think of it. The bill creates a 6-to-1 government match of any contributions valued at $200 or less for congressional and presidential campaigns. So to put it in simple terms, Every $200 contribution, the federal government will provide up to $1,200. You heard that correctly. Our Democrat colleagues want to take your tax dollars and use that money, folks, everybody watching back home, to fund campaigns of candidates across the country, regardless of whether or not you want that or would agree with them on the issues most important to you. The tax dollars of pro-life individuals, for example, could be sent to pro-abortion candidates. Second Amendment advocates would be funding the campaigns of gun control candidates, and the list goes on and on. So on its own, H.R. 1 would send chills down the spine of every American who believes in the foundational structure of our election system. But that's not all Democrats are proposing to do. H.R. 4 is a whole other can of worms. Democrats attempt to orchestrate yet another radical and unprecedented federal power grab over state-administered elections, this time under the guise of updating the Voting Rights Act. Upon its enactment in 1965, the VRA employed extraordinary measures to address pervasive state resistance to removing radically discriminatory barriers that did prevent minorities from exercising their right to vote. In 2013, the U.S. Supreme Court's decision in Shelby County v. Holder recognized an obvious fact, however, when it examined the Voting Rights Act, and it concluded that things have changed dramatically, of course, since 1965. That should be celebrated. The court reasoned that requiring states to pre-clear election law changes based on conduct a half-century ago was an unconstitutional invasion of state sovereignty. Republicans are thrilled that the VRA worked. We all are. The truth is that more Americans from minority communities are voting now than ever before, and overall voter registration remains high. This is a great achievement. In fact, voter registration disparities between minority and non-minority voters in states like Texas and Florida, North Carolina, Mississippi, my home state of Louisiana, listen, are below the national average, and they're actually lower than Democrat-run states like New York, California, and President Biden's home state of Delaware. However, Democrats would have you think otherwise. They want to bring pre-clearance back through H.R. 4 and have states seek approval from Merrick Garland's Justice Department before making any changes to election laws or redistricting. Again, this is a blatant federal power grab, and we shouldn't stand for it. Both H.R. 1 and H.R. 4 are contrary to the founders' intent, the plain text of the Constitution, and if they were ever fully implemented, they would further erode Americans' faith and confidence in our institutions. Y'all, listen, the fabric of our republic is becoming worn and frayed because of all this, and I remain hopeful that the people of our country will see these political charades for what they really are and rise up to make their voices heard. I do thank the chair and the ranking members for allowing me to testify this morning. Wish you all a Merry Christmas, and I yield back.
And we do thank you as well, Congressman Johnson. Thank you for your testimony. At this time, the chair will recognize Congressman Larry Bucshon, who represents Indiana's 8th Congressional District. Dr. Bucshon serves with me on the House Energy and Commerce Committee. He is a very important asset to that committee, and it's my joy now to recognize Dr. Bucshon for 5 minutes.
Thank you, Mr. Chairman. Chairman Butterfield, Ranking Member Stile, Ranking Member Davis. Thank you for allowing me to speak at today's Member Day hearing. I'm going to speak on COVID-19 safety protocols in place in the Capitol complex, and specifically the office of the attending physician. As a doctor, I don't think doctors should be put in a position to have to answer to political pressures, and that seems to be what has happened, rather than set forth guidance based on facts and medical expertise. From my perspective, this has happened time and time again throughout the COVID-19 pandemic and in the safety protocol decision-making process here in the House of Representatives. I believe it has offered an opportunity for this committee to re-examine the role of the attending physician and the office of the attending physician and depoliticize the office, removing it from the partisan overreach of the office of the speaker, regardless of which political party happens to be in the majority. The office of the attending physician was established to be the doctor on campus and attend to basic medical needs of the Capitol complex, not set protocols to respond to a national pandemic. The office is in need of modernization to reflect the times. This is why earlier this year I introduced H.R. 4862, the Office of Attending Physician Independence Act, which would remove the ability for political pressure to be put on the office of the attending physician by establishing a bicameral, bipartisan framework, much like that of the architect of the Capitol. And that has been in place since 1990. They would appoint and oversee the office of the attending physician. Rather than a lifetime appointment, the bill would make the office of the attending physician position a 10-year term with the opportunity to be reappointed, and establish proper congressional oversight of the office. Since COVID-19 is endemic in our society and will probably always be with us, I call on this committee to consider H.R. 4862 and move the bill through the committee process so that we can equip Congress with the tools it needs to respond to a pandemic and set proper safety protocols so that members and the American public can be assured that any guidelines are based on science rather than potentially as a result of political pressure applied by the majority party, again, whichever party that may be at the time. With approved vaccines now readily available for almost anyone in our society who wants one, as well as therapeutic treatments and almost 2 years of clinical experience to treat patients with COVID-19, there is no reason why we can't and why we shouldn't have guidelines in place to safely reopen the people's house and get back to doing the American people's business in an open and transparent manner. But sadly, politics, honestly, and the politics of panic are winning over reason and science. In closing, public health decisions must be made based on sound science and medical expertise. It is time to end the partisan quasi-oversight rule of the Speaker's office when it comes to Congress's public health decisions, and we must reform and modernize the office of the attending physician so that we can get back to effectively doing the people's work. Thank you, Chairman Butterfield, Ranking Member Stile, and Ranking Member Davis for allowing me to testify. Merry Christmas and happy holidays.
And thank you, Dr. Bashan, and Merry Christmas to you and your wife, the other Dr. Bashan. At this time, I'm going to recognize Congressman John Sarbanes. John represents Maryland's 3rd Congressional District. Congressman Sarbanes currently serves also on the Committee on Energy and Commerce. He serves on the Oversight and Reform Committee and is the distinguished chairman of the Democracy Reform Task Force. Congressman Sarbanes, you have approximately 5 minutes.
Thanks very much, Mr. Chair. I appreciate it. And to members of the subcommittee, thank you for having this important hearing today, for all the work you do to protect and to strengthen our democracy. The stakes for this work obviously could not be higher. The 2020 election demonstrated the need for wholesale democracy reform, which is what we are pursuing. Americans across the country were forced to overcome rampant voter suppression, gerrymandering, a torrent of dark money, just to exercise their vote and their voice in our democracy. Our election workers face threats, intimidation, and harassment. So there's a lot that we need to do. Less than a year ago, we witnessed firsthand some of our democracy's most fragile moments. Today, misinformation and disinformation about our elections continues to spread, and in many parts of the country, efforts continue as well, unabated, to restrict Americans' access to free and fair ballots. As you know, the American public is calling on Congress to take action to protect and expand the right to vote, increase government transparency, and safeguard the integrity of our democratic institutions. This House rose to the occasion in March, passing H.R. 1, the For the People Act, which is now being considered in the Senate, where it has been reformulated as the Freedom to Vote Act. Then in August, we passed H.R. 4, the John Lewis Voting Rights Advancement Act, as well. Taken together, these transformational bills will promote clean and fair elections and the dominance of big money in our politics and ensure the voice of the people is fairly represented in Congress, as well as strengthening key protections of the 1965 Voting Rights Act. Earlier, it was said that the Senate work on this bill now is happening while no one is watching. I would argue everyone is watching. The American people are watching with great expectations and hope that we will get this democracy reform over the finish line. It was also said that H.R. 1 is a partisan bill. Nothing could be further from the truth. If you look at the polling out there, Americans of all political stripes, Democrats, Independents, Republicans, support the reforms that are contained in H.R. 1. There's nothing really controversial in the bill. What's controversial is it's taken us this long to get it into this comprehensive package that can lift up our democracy, and that we haven't actually gotten it passed yet. That's what we are trying to do as we speak. The authority for many of the changes proposed, particularly in the voting arena to promote access to the ballot box, lies squarely within Congress under the Elections Clause of the Constitution. That's where it is grounded. There are many other things that have been said here I'd love to respond to, but I will restrain myself. Needless to say, the American public is very much in support of these changes. If Congress is successful in passing these critical pieces of legislation, the Committee on House Administration, your committee will have a pivotal role to play in guiding their effective and efficient implementation. Much as you did with the successful slate of field hearings conducted in states like Florida, Ohio, Georgia, and Texas as H.R. 1 and H.R. 4 were being crafted, I would encourage the committee to continue to garner the perspectives of a broad range of voters, stakeholder groups, and members of both parties. I'd also encourage the committee to conduct robust oversight to ensure that all provisions are operating as intended and evaluate the need for any further democracy reforms. Particular attention must be brought to the grassroots, small d, democratic infrastructure that our citizens rely upon to ensure that their voices are being heard and respected. Let me pause there just for a second. We have to make sure that at the local level, in every jurisdiction, those people that administer our elections, the professionals, the people who've done this because, frankly, they are patriots, they want to see a good election every 2 years, that we strengthen, that we lift them up. Our democracy is resilient. I'm confident that Congress can and will take meaningful action to restore Americans' faith in it. This committee, your committee, has been indispensable in catalyzing that effort and will be an ongoing source of vigilance when it comes to the integrity of our electoral politics. I've been honored to stand by your side in this fight to protect our democracy, Mr. Chair, and I look forward to continuing our efforts to redeem the vote, and the voice of every American. With that, I yield back. Thanks very much.
The gentleman yields back, and thank you, Congressman Sarbanes, for your testimony, and thank you for your friendship and your leadership. At this time, I think it will be appropriate for us to discharge the first panel. Thank all of you for your testimony this morning. And again, happy holidays to all of you and to your families and to your constituents. All right, we will now proceed to the second panel. Congressman John Catco is first up on the second panel. John represents New York's 24th Congressional District. He serves as a ranking member on the Committee on Homeland Security and as a member of the Transportation and Infrastructure Committee. Congressman Catco, please take it away for approximately 5 minutes.
Thank you, Chairman Butterfield and Ranking Member Stile and Ranking Member Davis for holding today's Member Day hearing. While I'm disappointed today's hearing is not before the full Committee on House Administration, I recognize the importance of the security and integrity of our nation's elections. And I appreciate the collaborative effort of Rodney Davis and myself on this in the Homeland Security realm and how it overlaps with House Admin. And we will continue to work to make that effort going forward. But however, as we look forward to a new year and the likely election of a new majority, I would like to bring to attention an issue that I have appreciated Ranking Member Davis's attention to, and that I know he will focus on as chairman of this committee. As a husband and father, I can attest to the fact that threats of violence against members of Congress and their families are a deeply personal issue for many of us. As a proud employer of a committed team of public servants, I also know the deep sense of responsibility that many of us feel when those threats are directed at our staff. This issue cuts across party lines, but has all too often been marginalized by partisan posturing and finger pointing. We all have a responsibility to turn the temperature down, but we also have a responsibility to take threats seriously and ensure an appropriate and full response whenever they occur. I'm appearing before the committee today to recognize the personal stakes of this issue, but just as importantly, to take a clear-eyed and practical view, recognize the threats against members of Congress for what they are, a dire challenge to the security and integrity of this institution. Simply put, we know that instances of these threats are increasing dramatically, stretching the resources available to Capitol Police and the Sergeant at Arms. In May, the Capitol Police reported a 107% increase in threats against members compared to 2020. But as the year comes to an end, we have a more complete picture. As of this week, more than 9,000 concerning communications and direct threats have been reported to the Capitol Police in the past year, which means it's probably a heck of a lot more than what actually occurred. 4,782, more than half of those, were directed against members of the House. And last month alone, nearly 400 concerning communications and direct threats were reported to the Capitol Police. We are confronted with a concerning and frankly dangerous security posture when we consider these numbers relative to the limited resources available to the Capitol Police's threat assessment section, especially compared to similar services like the U.S. Secret Service. Given that a significant share of the responsibility for securing this institution falls to this committee, it is imperative that we give this issue the attention it deserves. We have already received insights on the challenges facing the Capitol Police in the past year, including from the department's Inspector General, and it is time for us to act. To start, we need to have serious and substantive conversations on how to expand resources for threat assessment, enable any necessary structural reforms, and improve coordination between Capitol Police, the Department of Justice, and local police in response to threats against members and staff. I can tell you from far too many personal experiences that this is not where it should be, and we need to fix it. I say this not only as a member who has received multiple credible threats during my time in Congress, but as someone who has heard from members on both sides of the aisle regarding the real safety concerns facing themselves and their families. The cost of inaction could be both tragic and catastrophic, as members of this committee know all too well. Like many of my colleagues, I stand ready to work with the committee on this issue and hope that we're given the opportunity to do so. I want to thank you very much for allowing me the time to speak here today. I wish you all a happy and safe holiday season, and with that, I yield back.
The gentleman yields back, and we thank you as well, Congressman Catco. At this time, the chair is pleased to recognize another member of the Committee on Energy and Commerce, my good friend, Congressman Buddy Carter. Buddy represents Georgia's 1st Congressional District. Not only does he serve on the Committee on Energy and Commerce, but also a distinguished member of the House Committee on the Budget. I'm also informed that he serves on the Select Committee on Climate Change. Congressman Carter, you are welcome today. It's good to see you again. And again, thank you for joining our delegation when we christened the USS John Lewis some months ago. You are a great friend. Thank you very much. You're recognized for approximately 5 minutes. Congressman Carter, are you with us? Congressman Earl Buddy Carter, you're recognized for 5 minutes. The gentleman apparently is having some technical difficulties. I suppose we can move to the next witness. All right, the chair will now be in recess subject to the call of the chair.
Mr. Chairman, I apologize.
That's all right, Congressman Carter. I recognize your voice anywhere at any time. You are now recognized, Congressman Carter, for approximately 5 minutes.
Well, thank you, Mr. Chairman and Ranking Member Davis for holding this hearing today. It's extremely important. I appreciate it. I am disappointed that the hearing isn't before the full committee on the House Administration, but I am honored to appear before you today to discuss the importance of protecting the integrity of all federal elections and voters' faith in elections processes and outcomes. Because the next election will likely bring a change in control of this House, it is important that voters know that they can trust the results. When Republicans take control of the House following the next federal election, we will focus on reopening our Capitol for the American people and government in a transparent manner. Before I go any further, I do want to thank you, Mr. Butterfield, for your friendship and for your service on the Energy and Commerce Committee. As you know, that is a very important committee that does great bipartisan work. I still submit that it is the most bipartisan committee in Congress, and I'm very proud of the work that we do on that committee. And I want to thank you for your service on that committee and for your friendship as well. As you may know, I'm a licensed pharmacist. By profession, I am a pharmacist, and I say that because I've practiced pharmacy for over 40 years, and as a healthcare professional, obviously, healthcare is extremely important to me. And I find the current House rules related to mask wearing, constituent meetings, and Capitol tours far too restrictive and frankly disrespectful to the millions of Americans we all serve. Members of Congress are directly elected by the people, and many refer to the House of Representatives as the people's house. But the people, our constituents, are not able to visit our Capitol to witness their democracy at work. They are limited to watching hearings and legislative business on a screen, the most impersonal form of participation with their government. The House, under the Democratic Party's lead, has shut out the public. Members are prohibited from giving tours. Constituents can't personally visit their representative's office without going through a ridiculously cumbersome sign-in process, and just forget about letting constituents visit the House chamber. Meanwhile, on the other side of the dome, Senate offices can take meetings and give constituents tours of the same Capitol buildings we can't. It's understandable that certain precautions were necessary when the pandemic started, as we knew very little about the virus. But our knowledge has evolved. We now know to mitigate spread, and we have vaccines. So at what point is limiting constituent involvement in the democratic process no longer about the virus? Well, we hit that point a long time ago. The virus is here with us now, and it's here to stay. We have effective free vaccines for every American. It's time we open our Capitol back up and let the Americans that elected us visit their Capitol and their representatives without restrictions. Furthermore, the mask mandate is long past necessary. The District of Columbia recently removed its mask mandate. Why is it that I can walk into any grocery store, go to church, or go out to eat in DC without a mask? But when our staff and ourselves entered the Capitol and House office buildings, we are all required to wear masks. These are not safety precautions, they are Orwellian requirements. It's time we let our constituents, the American people, participate in their democracy like the Founding Fathers intended. And it's time to make scientific, medically based decisions about COVID mitigation methods. The rules in place right now are based on feelings, not facts. It's time to return to the pre-pandemic normal in our Capitol. Again, Mr. Chairman, Mr. Ranking Member, I want to thank you for allowing us to come before this committee today. This is very important. It's very important that we get our Capitol open again, that we allow our constituents, the people, to see the people's house firsthand in action. Again, Mr. Chairman, thank you for your friendship. Thank you for your service, and I yield back.
The gentleman yields back, and Congressman Carter, we thank you as well. Let's see, I'm told that we have 2, possibly 3 witnesses to go, and neither of whom may be on the call at this moment. Let me just call their names. Is Congresswoman Tenney with us, or Congressman Taylor, or Congressman Stover? Hearing no response.
Mr. Chair?
I believe Tenney may be there.
Yeah, Ms. Tenney is here.
Good morning, Congresswoman. Congresswoman Claudia Tenney represents almost said North Carolina's 22nd District, New York's 22nd Congressional District. She currently serves on the House Committee on Foreign Affairs and the Small Business Committee. Good morning to you, Congresswoman. You have approximately 5 minutes.
Thank you. I apologize for the technological difficulties here, but thank you Thank you, Chairperson Lofgren, Ranking Member Davis, and all the distinguished members of the committee for giving members the opportunity to share their priorities with you today. The integrity of our elections is essential to the function of our constitutional republic. Over the generations, countless Americans have fought, marched, died to protect and expand our sacred right. Therefore, it is essential for the American people to know that their elections are fair and that only legal votes are counted. However, the past several years, the essential trust in this sacred institution has been tarnished. First, my progressive friends who question the legitimacy of the 2016 election for no other reason than they dislike the individual elected, that's the opposite of democracy. Then there was the unprecedented lack of transparency as well as politically motivated policies that undermined confidence in the 2020 pandemic election and led to numerous errors, which my election proved. Residents of New York's 22nd Congressional District saw these shortcomings firsthand every day for over 100 days, actually. This last year, my congressional race took, as I said, almost 3 months to decide. Hasty rule changes and bureaucratic incompetence left approximately 700,000 Americans without representation in Congress for over a month. These are not the experiences that instill faith in our system. They undermine the trust needed for the functioning of a representative system of government. To prevent this from happening again, I founded and currently co-chair the Election Integrity Caucus, which educates members on the issues and advocates for common sense reforms and solutions to ensure that we have secure elections. Thankfully, we have proven examples to pull from as many states have acted to shore up their electoral system. These systems include common sense voter ID laws, updating voter rolls, banning ballot harvesting, and requiring all votes to be counted on election night. However, these critical measures face resistance from political forces across the country, including here in this body and on this very committee. These partisans seek to centralize electoral administration and undermine the basic security of our elections. The first such effort in the House was the passage of H.R. 1, which aimed to completely upend our federalized election systems, centralizing it here in Washington, D.C. This bill would undermine the authority of the states to make their own voter registration and election laws, as well as empower partisans to overturn reforms by democratically elected state and local officials. First, this misguided legislation would ban, of all things, voter ID, eliminating an essential and common sense safeguard many states have enacted already to secure voting integrity. Next, it would eliminate the bipartisan structure of the Federal Election Commission, reducing its size from 5 and allowing it to partake in partisan enforcement actions. Last, it would mandate the legalization of no-fault absentee ballots, ban witness signature or notarization requirements, and force states to accept absentee ballots up to 10 days after the election. These changes would blast open the path for voter fraud, enabling bad faith political actors to simply create votes they need. Paired with a mandate to legalize ballot harvesting, it makes you wonder what the drafters of this legislation thought this process really was about. Even if you do not agree with this criticism, you must acknowledge that making voters wait weeks after an election to know the result will only undermine trust in our system and hamper political representation. We've had Democrats testify in our committee stating that this is the wrong-headed move. Now that this legislation has thankfully stalled in the Senate, House Democratic leadership is pushing their equally misguided H.R. 4. This bill would completely centralize the control of elections with unelected bureaucrats in the Department of Justice, providing them with the power to change voting places, voter ID, registration requirements, and redistricting every state. And finally, this bill would also create a new practice-based pre-clearance requirement that would apply to all political jurisdictions, whether or not they are included in the new unjustifiably strict 10-year coverage formula. With these changes, no state or local government would be safe or free to adjust their election system, even if they are acting in good faith to meet the needs of their system, regardless of party. Instead of these unwise bills, Congress should focus on reforms that respect the rights of the states, while also repairing actual shortcomings in election integrity. As an example, during the 2020 election, Mark Zuckerberg poured over $350 million into the Center for Tech and Civic Life, a left-leaning nonprofit. This money was then funneled directly to boards of elections, completely bypassing any accountability or oversight from state legislators or local governments. In addition, this money went disproportionately to Democratic districts selectively driving up turnout in these areas while ignoring more conservative and rural areas. My response to that has been HR 4290, the End Zuckerbucks Act. This legislation will prohibit 501c3 tax-exempt organizations from providing direct funding to official election organization. The right to vote is sacred. The administration of our elections should be in the hands of the American citizens, not the highest bidder or wealthy Silicon Valley donors. So I see my time is up. Can I continue?
You can have 15 more seconds.
Okay, thank
Want
you.
to wrap it up?
Another topic I just want to talk about is these temporary election rules that many states are putting out in response to pandemic elections. One that scares me right now that's happening in New York is the voters spoke this year in November, stating that they did not want no-ask mail-in vote, no-ask absentee mail-in ballots. Our current governor is now trying to put in legislation to overturn the will of the voters by an overwhelming majority, said that we should not have no-ask mail-in ballots. She is now trying to turn the entire state into a mail-in ballot state, even though over 50%, almost 60% of the voters across New York rejected this. I hope that this committee will consider these remarks and make sure that we do not pass HR 1 or HR 4 in any revised state again, and come up with common sense voting reforms. Thank you, and I yield back.
And thank you, Congresswoman Tenney. Thank you for your testimony. And on behalf of this committee, we wish you and your family and your constituents a very Merry Christmas. We're moving right along. I'm informed that Congressman Taylor has now joined us. Congressman Van Taylor represents Texas, the 3rd Congressional District of Texas. He currently serves on the House Committee on Financial Services. Good morning to you, Congressman Taylor. You have approximately 5 minutes.
Thank you, Mr. Chairman, and thank you, Ranking Member. I want to make sure you guys can hear me.
Yes, we can.
Okay, good. Great to be with you this morning. Appreciate this topic. I actually, prior to being elected to public office, was an election judge. So I have experience in the administration at the polling station level of elections. And I wanted to first to say election fraud is deeply upsetting. I've seen it on a personal level. My first time that I was a poll watcher, I watched a woman come in to vote on election day, and she was informed that she had already voted. And she said, well, that's impossible. I've been out of the country the last 2 weeks. There's no way I voted. But somehow, either someone stole her identity, and this was at a time when Texas didn't have voter ID law at that point, or a clerk checked the wrong box. But either way, the look on that woman's face, that look of distraught, that her voice had been taken from her, is something that I've always remembered. It's deeply upsetting and real. And I think it is instructive that we need to be mindful to make sure that the procedures that we put in place when it comes to elections are ones that are going to be thoughtful, effective, and are going to reduce the number of times that people find themselves disenfranchised, like that woman I saw on that election day. And so one of the key things I would say is that election laws should be done by the states. That's actually in the Constitution of the United States. When I was in the state legislature, I worked on election laws and became familiar with a lot of the difficulties of passing them. They're very complicated, extremely difficult to do. My first bill in the state legislature actually required not only changing the entire election schedule for Texas, but actually I needed a constitutional amendment to sort of make it work. And when I asked one of the sponsors of HR 1, hey, does this bill comport with state constitutions? What states are going to have to change their constitutions? What states are going to have to change their laws? Because there are requirements in there about establishing different designating different people to do different functions within the election process, which some states may not have. And the answer was, we haven't looked at that, which was really shocking to me. If you're going to have a successful election bill, you've got to really sit down and think about it very carefully. And even when you do sit down, and even when you do think about it, and inadvertently, even with the best of intentions, there are going to be errors. And those errors require cleanup bills. And something that I don't have a lot of confidence in the U.S. Congress today is the ability to pass cleanup bills. I've seen the difficulty in this place of passing even the simplest of bills. And, it is my project. I would think that if HR 1 were to go into law, most states would be operating under court orders to run their elections because they would not have had a chance to clean up their state constitutions or their state statutes in order to comply with the various and sundry requirements of H.R. 1 that, as far as I can tell, as far as I'm aware, have not been actually run through the 50 different states to say, hey, what are you guys going to have to do to clean things up? I'll shift a little bit to election fraud. Having worked on my first big bill in the state legislature was an election bill. I would get frequent calls on election fraud. And the majority of the election fraud that I saw in the state of Texas had to do with mail-in ballots. Mail-in ballots are where you have problems. I watched basically criminal enterprises falsify requests for mail-in ballots, fax those in, and then they would literally steal the ballots out of the mailbox. These thieves would typically target elderly minority individuals because they thought they were less likely to participate in certain elections. And they actually threw elections. They actually decided who would sit on city councils and school boards and commissioners' courts here in Texas. And it's deeply upsetting when you see that and find it. And it really speaks to the importance of us, as we talk to our state partners. I really think that's where election law should be, by and large, that they make sure that we have procedures in place that are going to be effective at stopping this kind of fraud because it's real. And finally, I'll just talk about confidence. There is a crisis of confidence in our elections in this country today. Many Americans, and I hear about it every day in the 3rd District, people are worried that their vote doesn't count because they think that our elections aren't run right. And so I think that and I particularly encourage my colleagues on the other side, audits are good. Going through, figuring out what went right, what went wrong, and making it better, I think it's something that we should all be for because that ultimately is going to give people confidence in our elections. And that confidence in elections ultimately reflects on elected officials. Our legitimacy as elected officials is contingent upon people thinking the elections that elected us are in fact legitimate. Mr. Chairman, I appreciate your indulgence to give me a little extra time. I yield back.
The gentleman yields back, and we thank you, Congressman Taylor, for your testimony, and we also wish to you, your family, and your constituents a very, very Merry Christmas. As we begin to wind down, I've heard several of my friends make reference to the fact that the federal government has no role in administering elections at the state level. And while that is generally true, I had to pull it up on my iPhone just to make sure that I'm absolutely correct. I'm looking at Article 1, Section 4. There is a but in that section. It reads, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. And so my friends are absolutely correct about that. But there is the word but. But the Congress may at any time by law make or alter such regulations except as to the places of choosing senators. I just wanted to put that into the record. And while we're on that subject, I am a student of the 15th Amendment. I've used it many times over my legal career, and just want to put the language of the 15th Amendment into the record. It reads as follows: the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. So thank you to my colleagues for your testimonies today. I want to thank especially my good friend who is beaming in from the great state of California, Congressman Pete Aguilar. I understand that there's a 3-hour difference between the time zones, and this hearing started at 9 o'clock Eastern, which means that it was 6 a.m. Pacific time. And so as we close out, I want Congressman Aguilar, I understand that he does not wish to make a statement, but he's such a great friend. I just want him to say hello to the committee. Congressman Aguilar?
Thank you, Mr. Chairman. I appreciate it. Yes, I am here. I am present. I wanted to make sure that the ranking member understood that I wanted credit for being here at this hearing. So I appreciate it. I expect flowers and chocolates delivered as well from the ranking member. Thank you, Mr. Chairman. Such weighty topics that we are discussing here, and obviously under your leadership, the House Administration Election Subcommittee has done robust work over the past few years with field hearings done in a bipartisan way, from taking testimony from our colleagues like our colleague from Texas, and finding out exactly what Americans are going through and finding out the barriers that they are facing themselves. We can only do that by hearing testimony. So I appreciate your willingness, Mr. Chairman, to have us out on the road and then to take in testimony in person and virtually from experts and individuals around the country in order to make our democracy stronger and to make sure that we continue to have everyone exercise their franchise to vote.
Thank you, Congressman Aguilar, and I must say that you look a little different at 7 o'clock in the morning as opposed to 12 noon. But either way, we welcome you and thank you for your friendship. Yes, I recognize the gentleman for unanimous consent request.
Mr. Chairman, I seek unanimous consent to submit Mr. Stauber from Minnesota's statement into the record.
Without objection, the statement will be received.
And I would also like to note to my good friend, Mr. Aguilar, that I wish him a Merry Christmas and will deliver a Christmas present to his office yet today. And appreciate you, Mr. Chairman, for holding today's hearing. I wish you a very Merry Christmas.
I thank the gentleman. I look forward to another good year next year. And we will continue to be friends even after my departure from Congress, which will be 12 months from now. Let me close by asking unanimous consent that a written statement from another colleague, Mike Levin of California, that statement be entered into the record. Hearing no objection, it will be received. Are there any further remarks? Any good statements from any of our colleagues? Hearing none, and without objection, the hearing of this subcommittee on elections stands adjourned.